Hi friends, this is Raghu, your advocate. When does manufacture really happen? Is squeezing a fruit or crushing a seed enough? Today, the Supreme Court drops a logic bomb that will shake customs, traders and tax departments alike. Let's break it down one slide at a time. Why this question is crucial? This word manufacture may sound boring, but it decides who pays taxes, who gets exemptions and who walks free. From GST to customs, excise to income tax, it all starts with its one word. So it's not just grammar, it's money, law and power. The burning question. Here is the million rupee question. If I process something, is that manufacture? If I crush, dry, filter, have I made something new or just modified the whole thing? That's what the Supreme Court settled in a February 2025 judgment. What was the case about? The company Noble Resources imported crude demugged soyabean oil. They said it was a food product, so it should be tax-free under an official government scheme. But customs was like, nah bro, that's just soyabean in disguise. Pay up rupees 1 crore in duties. Noble defense strategy. Noble clapped back. They argued, dude, this ain't raw soyabean. We have put it through cleaning, flaking, solvent extraction. It's literally a new thing. Also, how can a 2004 circular overrule a 2003 government law? Boom, game on. Supreme Court drops the hammer. The Supreme Court said, hold up, a circular is just a departmental note. It can't change or expand a statutory law. So the customs circular legally meaningless, invalid, out the window. The 5 essential tests of manufacture. Then came the master stroke, the 5-part test. Was there a process? Did it change the original material? Did a new product emerge? Does it have a new identity or use? Does trader treat it as something different? If S is equal to manufacture. Applying it to a soybean oil. Let's apply it. Raw soybean goes through a high-tech makeover, cleaning, chemical extraction, distillation. It comes out as crude demugged soybean oil. New product, new use, new market identity. Result, it's not a farm product anymore. It's a manufactured. Verdict of the Supreme Court. So, what did the court say? Crude soybean oil is not agriculture. It's a manufactured product. Custom circular is invalid. With 1 crore demand set aside. Noble wins. And so does legal logic. A shockwave for customs. For the customs department, this was a total shocker. They thought they should stretch the law using a circular. Supreme Court said, no way. A circular can't become the law. You can't make new rules in the back office. The verdict, a knockout punch for overreach, a total reset for legal limits. The big picture takeaway. The Supreme Court redefined one thing loud and clear. Manufacture is identity shift, not just physical change. And departments can't invent new rules by typing memos. Law is law and law wins every single time. Famous precedents. This wasn't the first time Supreme Court spoke on manufacture. Whether it is in Delhi cloth mills in 1963 or in Payo food packers 1980 or Jai Bhagwan oil 2009 and recent mineral oil corporation 2015 and now Noble Resources to 2025, the crown jewel tying it all together. And the final thought, the lesson in law, you don't just do something, you must transform it. Whether you are an exporter, a trader or a curious citizen, know this identity matters. And the Supreme Court, it just laid the final word on manufacture once and for all. If you loved how we broke down this judgment, don't forget to hit like, comment and share. I am Advocate Nedunuri Raghu, simplifying the Supreme Court for every Indian. See you in the next one where law meets logic and justice gets decoded.